So I'm going to say welcome to the First Coast Free Thought Society Zoom Room. The First Coast Free Thought Society is an organization of individuals who prefer science and reason over religious dogma and fanaticism. We've enjoyed the non-religious community of Northeast Florida and beyond since 1998. We're now in our 25th year. We are also the proud Jacksonville chapter of the American Humanists Association. We're on Facebook, Twitter, Meetup, Instagram, and YouTube. You can watch recordings of all of our meetings on YouTube. We meet socially through our secular Sunday gatherings in the park and our book and movie discussion groups. And then there's the Freethinker newsletter, to which we invite your feedback and your submissions. You may learn more about our website at fcfs.org. Now, I do have a question for the floor. I wonder if anybody here is new to us tonight. Is this the first night that you are joining us? And if so, are you willing to share how you heard about us? If not, that's okay too. Anybody new? And if you do want to speak, there's an emoji button that has a hand wave that raises your hand. That's a good way for me to recognize you and then also unmute your mic if you want to speak. All right, nobody? Okay, that's fine. That's fine. You may all be return visitors. That'd be great. Well, anyway, welcome everybody. We're all volunteers, yet we incur expenses, largely promotion. We promote it online, on the radio, and in print. So what's next? Billboards, sky banners? If you know of a viable place for us to promote, please share it with us. We also have some associated costs for our website and our fees for regulatory compliance as a 501c charitable organization. So if you can see your way clear to offer a membership donation of $20, $50, or any dollar amount, you'll be the reason we're able to continue our public outreach. We're tremendously grateful for all who have become members and made donations. We need you and we appreciate you. Now, there is no Zoom event next month in August, but upcoming guest speakers we can look forward to include in September, Eric Freiberger, Doctor of Philosophy at Jacksonville University. His presentation is titled, How Conservatives and Liberals Think About Liberty. Then in October, we have Dr. Nick Seabrook. He's the political science professor and public administration chair at UNF. He will discuss his new book, One Person, One Vote, A Surprising History of Gerrymandering in America. Then in November, Mark Potok, formerly of the Southern Poverty Law Center, an expert on racism and hate groups, he will discuss the far-right hate groups and anti-Semitism. Then in December, we will meet in person at a local restaurant for our annual Human Light celebration. Then in January 2024, we'll begin the year with our third Free Thought Free-for-All, no guest speaker, no holds bar, no topic off limits, just us to discuss whatever comes to mind. Check your local listings. Sign up to our meetup page. Sign up for our newsletter and our email announcements. Stay in touch. You can do all of this at our website. Now, tonight, we are pleased to have with us staff attorney Brandon Scheck from the Innocence Project of Florida. The Innocence Project is a nonprofit organization committed to exonerating individuals who have been wrongly committed through the use of DNA testing and working to reform the criminal justice system to prevent future injustices. The Innocence Project was founded in 1992 by Barry Scheck, no relation, and Peter Neufeld, who gained national attention in the 1990s as part of the dream team of lawyers who formed part of the defense in the O.J. Simpson murder case. Please use the Zoom hand raise feature found at the reactions button to raise your hand when it comes time to speak and engage in a conversation or a discussion at the end of Brandon's presentation. Should you prefer, you may message a question or a comment via the Zoom chat. Now let's mute our mics until it's time to speak. Please know we are recording the presentation for posterity and YouTube later on. As a side note, we don't know what might be said during our discussions. We're open to the public. Sometimes people say things that make us cringe, and sometimes we nod in quiet approval, and sometimes we cheer. Well, at any rate, let's begin by saying thank you, Brandon, for graciously offering us your time, your expert, and your wisdom and insights. We appreciate you. We are now all yours, Brandon.
Thank you for that, and thanks everyone for having me. Hopefully, I don't say anything that makes anyone cringe, but that might just be the nature of the work that we do here. Good or bad, there might be some cringe moments. So I appreciate everyone having me. I fully believe that our organization fits right into the space of science and reason and getting to the truth of the matter. And so um, I feel like y'all are the perfect audience to hear about what we do here in Florida, both in the past and into the future. And so I'm going to share my screen because I have a PowerPoint. See if I can get this up and running. Okay, I hope everyone can see my screen. That's me. I had a very kind introduction, so I don't need to say anything more about myself. But I will say a little bit more about our organization and kind of what we're doing here at the Innocence Project of Florida. So, like what was said, we are a nonprofit organization based in Tallahassee, and we work um, anywhere in the state of Florida to help wrongfully convicted people in Florida prisons obtain their freedom and rebuild their lives in freedom, essentially. We are currently a staff of 10, so we have 2 lawyers, including our executive director, 2 investigators. We have 2 people who work in our intake department, who are our kind of front lines communication with folks in prison. We have a social worker, a fundraiser, a communications and social media person, and a finance and HR person. So that's really the staff, what we have here. And we're a small shop. We receive over 1,000 requests for assistance each year. And essentially, where and how do we get our clients? So people in prison write to us seeking assistance. And so these are people who they've been accused of a crime, they've been convicted of the crime either through a plea or through a jury trial, and they lost on their direct appeal if they appealed. And so then they end up in what we call post-conviction land. And so in post-conviction land in Florida, you have no right to counsel, and it's extremely hard to prove your innocence. And so those are folks who might apply to us. We're often a office of last resort, if you will, for people who fall into that boat, who have been convicted, their conviction has been affirmed, and they claim their innocence, their actual innocence. When I use the words innocence or actual innocence or wrongful conviction, what I'm talking about is very specific. I'm talking about somebody who was convicted of a crime for which they had nothing to do with. So there might be other things that we can think of that we might personally believe are wrongful, right? I can imagine something that I think that I see a lot that's quite unfair. So imagine a murder case where you have the person who's the actual murderer, let's say it's a shooting, and the person who actually pulls the trigger, and you have someone who's the getaway driver, right? And sometimes the getaway driver actually gets a longer sentence, more severe sentence than the person who actually pulls the trigger. We might feel that that's wrongful, but that's not what I'm talking about. The getaway driver has legal culpability. That might be a sentencing issue that I'm talking about, but not a wrongful conviction, how we might define that. Also, we don't take cases where there's like a legal defense, right? Obviously, self-defense is a very legitimate thing. It's well established in our law and in our culture and society. But if someone committed the act but is claiming self-defense, that's something that a jury can decide whether they believe that or not, but not something that we would take, type of case that we would take. So again, we're talking about cases where somebody's been convicted of a crime that they had nothing to do with. And so again, we receive over 1,000 requests a year. We have to screen those. We have a very diligent intake process where we're looking for, telltale signs of wrongful conviction, things that I'll talk about in more depth later. We investigate cases that present meritorious claims of actual innocence. And, when we take on somebody as a client, we advocate for their exoneration in a couple of different ways, possibly. One is traditionally through the courts, and two, a newer concept. Well, it's newer to the state of Florida. These have been in existence in other states for a much longer time, but the kind of notion of what we call a conviction integrity unit or a conviction review unit. And these units are entities that are within a state attorney's office, so a prosecutor's office, and they're kind of doing on the state side of things, on the prosecutor side of things, what we might be doing here at the Innocence Project of Florida on the defense side. So these units there are 20 circuits in Florida. They exist really in 4 circuits. So you have the 17th Circuit, which is Broward County, the 13th, which is Hillsborough, the 9th, which is Orange and Osceola County, and the 4th Circuit, which is Duval, Clay, and Nassau, which might be of particular interest to some or all of y'all. They have these entities in the state attorney's office where somebody, an assistant state attorney or multiple assistant state attorneys are reviewing applications where people write directly to the state attorney's office saying, hey, y'all's office convicted me 10, 20, 30, 40, however many years ago, but I actually didn't do the crime for which I was convicted. And so we sometimes work with them in terms of cases of common interest, if you will, people that write to us, people that write to them, and we try to get to the matter of the truth. Can we develop new and different evidence that wasn't presented to the jury that demonstrates this person's actual innocence? And when we can, we work together, the state attorney's office and us as defense counsel, through the courts to effectuate that person's exoneration. And we've done that several times in Jacksonville with the conviction review unit in the 4th Circuit. So then that's kind of the legal part of this. We also care about our clients as human beings. They're not cases. They are very much people, and they're very much, they have, many of them, not all unfortunately, but have a large group of advocates, family members, friends, people that believe in them, and have for a very long time, if not their whole life. And so we care. We have a social worker who works with these folks while they're incarcerated, and hopefully once they are exonerated or released from prison. And then through that transition service from incarceration to the free world, and then for however long somebody needs our assistance, and which might be for the rest of their life. I've had clients who have been in for 35, 40 years. And so, they were convicted in the 80s, no technology, no phones. It's like a whole nother universe out here now. And so that takes a very large toll in terms of the next chapter of someone's life and trying to figure out all of that. And so we take really great pride in our social services that we're able to provide folks. And then, of course, arguably the most important part of all of this, or at least, as significant as any of the legal advocacy, is reforming the system. We learn a lot about these wrongful conviction cases, trends, takeaways from cases that happened in the past, and we don't want those errors to replicate themselves in the future. Through the legislature, through the day-to-day practice within the criminal legal system, we want to take what we've learned and make sure that, to the extent that we can, things improve in the future. Because what's the point of trying to fix past wrongs if those wrongs are just going to keep happening in the future? And so we need to take what we learn and we need to apply it moving forward. And we try to do that through our legislative and policy missions. So that's like my one side that explains everything that we do. Not everything, but most everything. And I want to kind of now talk about the history, a little bit of the history of like, what the heck am I talking about when I'm talking about the innocence movement and like greater notions within the criminal legal system. And so historically, people never thought that wrongful convictions ever occurred because they were so rare. Once you were convicted, it was virtually impossible to overturn your conviction on grounds of innocence. And the main reason for that is what we call the myth of infallibility. And so this is what the criminal legal system is guided by. Criminal legal system is largely in denial that it was even possible to convict an innocent person, really because, as the argument goes, there's so many layers of process and protection, from pretrial to trial to a direct appeal where you get to argue about the things that you think went wrong at your trial. The idea that this process produces reliable results, and it has for many, many years. And then once that process is extinguished and the conviction is final, then the criminal legal system is driven by finality over anything else. And therefore, it's virtually impossible to convict somebody who is innocent because essentially you've had your bite at the apple and you don't get another one. That's the overarching principle of the criminal legal system. And so the myth of infallibility is really embedded by certain misconceptions about human behavior that, again, are historical. One is that eyewitness identification evidence is very, very accurate. So you have and you see this like in court dramas, and you see this in court, in real court. The eyewitness comes into court and they express sureness and confidence in their identification, and they point to the defendant sitting at the defense table who might be the only Black person in the room, but nonetheless, it's very convincing to the jury. And we thought that for a long time, that expression of confidence in the identification reflects strongly on its accuracy, on the truth of that identification. Another misconception is that individuals who are innocent would never confess to a crime that they didn't commit. I think generally this is something that people really believe in. People believe that they themselves would never confess to a crime, something that they didn't do, especially I'm talking about like a very serious criminal act, like a rape or a murder, or, the most serious crimes that you could think of in our society. But police are trained in various techniques that are meant to elicit confessions, because confession evidence is actually the strongest evidence that exists. The weight of a confession it has more weight than any other type of evidence to a jury. That's what the social science research tells us. And so confessions are very powerful in court. Essentially, you have the person sitting there at the defense table, and the jury hears them say that they did the crime in their own words, in their own voice. And that's very, very powerful. But those techniques that law enforcement are trained to use to elicit confessions, some people, like children, people who are mentally ill, people with diminished cognitive capacities, people who are particularly susceptible to authority, are very vulnerable to these techniques. And under the right circumstances, they might confess to something that they didn't do, possibly to get out of the situation. And so that's, we're talking historically, and some of those things that I was talking about very much still exist here today. But in the late 1980s and into the early 1990s, things changed a bit when DNA testing became integrated into the criminal legal system. Now, of course, initially DNA testing was used to solve crimes, to identify suspects, and to prosecute them in court. But a few years later, in 1992, well, defense lawyers started realizing that the same technology, the same science that was being used to solve crimes, to prosecute people, could be used to examine whether people who are sitting in prison convicted of crimes that happened in the past, they might be able to use this new technology to demonstrate their actual innocence and to free innocent people in older cases. So that's the premise for how the Innocence Project in New York was created in 1992 by Barry Scheck and Peter Neufeld. They created this clinic out of Cardozo Law School to essentially find cases that presented meritorious innocence claims that could be, that DNA testing, if exonerative, would demonstrate somebody's actual innocence, meaning that the DNA testing itself was probative of the issue of innocence. And so DNA testing was really the gateway to understanding that the criminal legal system is fallible, that people are convicted for crimes that they did not commit, and to start the process of beginning how and why this happens, and the frequency in which it happens. And so, beginning in 1992, these entities started popping up across the world, really. Innocence organizations were created in many states and in many countries, some as law school clinics, some like IPF as freestanding nonprofit organizations, in law firms, in public defender agencies. And again, these organizations were created initially to prove people innocent through new evidence, and that evidence initially was DNA testing. IPF was founded in 2003, and so now this is our 20th year of operation here in Tallahassee. And so that's a little bit about the history. I want to go into numbers because I think numbers really paint the scope, or can help us paint some aspects of the scope, in terms of what is this issue? What is the significance of this issue? So this issue is certainly not trivial. The National Registry of Exonerations is an entity that is based out of the University of Michigan and Michigan State. They collect data and really data since 1989, which is going back to where we have good data on this type of stuff, reliable data on this type of stuff, and pulling together and cataloging and, identifying the criteria of known exonerations, meaning cases where somebody has actually been vindicated in a court based on new evidence of their actual innocence. People who have previously been convicted and then subsequently exonerated. And so since 1989, there have been roughly 3,300 people across, and this is only data for the United States, so this doesn't even count the international exonerations, but 3,300 since 1989. And it's pretty staggering if you think, but almost 30,000 years of life lost amongst those 3,300 people. And in Florida, we see at the bottom, 91 exonerations, almost 1,000 years lost. And so I've been talking a lot about DNA exonerations, and I think it's like very understandable that most people think that this 3,300 number is comprised mostly of DNA exonerations. Actually, that's not true at all. There have only been about 576 DNA exonerations out of this 3,300 number. And so that means about 2,750 of those exonerations are non-DNA exonerations. And again, so DNA was really our gateway into understanding that this is a true phenomenon in our criminal legal system, that people are actually convicted although they're innocent. And the lessons learned from those DNA exonerations, what was the evidence that the state presented at trial to convict this person, whether it be eyewitness identification, a confession, informant or incentivized witness testimony, government misconduct, what got them convicted. And now we can kind of apply those things, whether the case has DNA evidence or not, because most cases don't have any DNA to test. And yet an innocent person doesn't pick and choose what type of case that they're wrongfully convicted for. And so we shouldn't hold that against them, whether their case has DNA or whether it doesn't have DNA. And since like the mid 2010s, the Innocence Project of Florida has eliminated the criteria that a case has DNA in order for us to work it. We now take non-DNA cases, and I would say 90% of our, at least 90, maybe 95% of our cases are non-DNA cases, where DNA testing is not the vessel, if you will, for identifying innocence. And so the other point to make about this 3,300 number is these are known exonerations. These are cases where people have been vindicated by a court. The academics that research this area, they've kind of tagged this notion of the dark figure of wrongful convictions as the concept that we don't actually know how many people have been wrongfully convicted. There are many people who are in prison and in prison in Florida who write to us who say they were wrongfully convicted, who say they were innocent. We have many clients, but even beyond that, just many people in general who claim innocence. And of course, not all of them are telling the truth, but some percentage of them are. And so the academics say that out of all the people in prison here in the United States, about 4 to 6% of them are actually innocent for the crime that they've been convicted of. If you use Florida, for example, there's about 80,000 people in Florida Department of Corrections and Florida prison right now at this moment. And if we say 5% of them, I'm not very good at math, but I think that number is 4,000. 5% of 80,000 is 4,000. And so, if the academics are correct in terms of their like conservative estimate, that's 4 to 6%, we call it 5%, that's 4,000 people who are sitting in the Florida Department of Corrections right now who are actually innocent of the crime for which they were convicted. And of course, the most serious sentence that we have is the death penalty. We think of death eligible cases as the most serious cases in our society, right? Murder cases is somebody or multiple people perished. Like we want to get those cases right. You would think. If we're going to have the death penalty, we want to make sure that the people who receive the death penalty are absolutely guilty. Of course, I don't believe in the death penalty, but if we're going to have a death penalty, you would hope that the people there are actually guilty. And of course, that's not always true. The death penalty is just like with all facets of our criminal legal system, susceptible to error. I say this a lot of times, um, whether it's the automotive industry, the manufacturing industry, the aviation industry, there's going to be an error rate in every single industry. You know, we would hope that the error rate is small, and in many industries, there are safeguards that we can put into place to try to make sure that that error rate is as small as possible. But, you know, even in industries that are driven by machine, there's going to be an error rate because humans are fallible beings. I make many errors on a day-to-day basis, and I think many people do, and some are better than others, but there's always going to be an error rate. The criminal legal system at every single level, from investigation to prosecution to defense to juries to judges, are all human beings, and there's going to be an error rate in our system. We hope it to be small. I think that's wishful thinking. I think our error rate in our criminal legal system is a lot bigger than we would hope it is. And this creeps into the death penalty just like anything else. So there have been 192 people who in this country who have been sentenced to death and who have later been exonerated based on evidence of actual innocence. Maybe not surprisingly at all, Florida leads the way in terms of the most people who have been sent to Florida death row who have been later exonerated by evidence of actual innocence. So 30 of the 192 are Florida cases. And this, of course, again, like I was talking about earlier, only talks about known exonerations. This does not talk about people who were executed who later evidence of actual innocence developed, or maybe the evidence of actual innocence developed before their execution, but the individual was not vindicated in court and therefore they were executed. And so there are definitely cases where people have been executed for crimes that they were proven to have not commit. And so that, of course, is not encompassed here in this 192 statistic. And of course, this whole conversation cannot be had without talking about race. The Black population in the United States is about 13 to 14%. The percentage of the prison population who are Black is about 35%. And the percentage of exonerated people who are Black is 53%. And the percentage of exonerated people from death row who are Black is also about 53%. And so, of course, we can see how the issue of wrongful conviction disproportionately affects people of color, and most significantly, Black people. Again, I kind of hinted on this, we would hope that if there are errors made in the criminal legal system, it's going to be like more petty offenses where they might just slip through the cracks, and that's not necessarily okay, but that person isn't going to prison for life or a death sentence, right? And we actually see that the opposite is true. So out of all of that 3,300 number that I was talking about earlier, about 37% of those cases are murder cases. And so we're talking about cases where people are often receiving life sentences, life without parole sentences, in Florida, possibly a death sentence. And so I would just say anecdotally, the vast majority of my clients are serving life without parole sentences. And so, these are the most serious offenses that one can commit, that they've been convicted for, and yet they got the wrong person, right? And so just one more piece of data. I've been talking a lot about wrongful convictions generally, but how do they happen? There are a lot of different contributing factors. of ways in which somebody might be wrongfully convicted in the circumstances. But if we look at all of the known cases and we pull out the contributing factors, and of course, there might be more than one contributing factor in a particular case. That's why this chart shows numbers that added together would be more than 100%. But we see certain trends among cases, and it's really illuminating in terms of how and why people get wrongfully convicted. And so, I was talking about one of the kind of misconceptions that leads to the myth of infallibility is the accuracy of confident eyewitnesses. And yet there are known exoneration cases where somebody was exonerated by DNA evidence, where the person was identified by 4, 5, even 6 that I can think of eyewitnesses. So you have 6 people that come into court and they say this person committed the crime, and yet DNA evidence proves that they didn't. And so just because somebody makes an identification doesn't necessarily mean that they're accurate in that identification. Of course, we have official misconduct. That could be from law enforcement, that could be from the prosecutor's office, that could be from a scientist doing lab work on the case, that could be from an expert, a state expert, that could be from a defense attorney, of course, that could be from any number of people that might be affecting the outcome of the case. So these are just some common exonerating factors, and these are the types of things that we're looking for when we're screening for cases in our intake department. Of course, I've been talking about history and I've been talking about data, and I think the most important part of all of this are the people. And so IPF has helped free and exonerate 30 people here in the state of Florida over our 20 years of existence, and more to come. Hopefully soon, more to come, actually. These are real people, they're real families, they're real communities who are affected by wrongful convictions. These people aren't cases, and they're not statistics. When wrongful convictions occur, the damage is widespread. Of course, we think about the exonerated person who lost years or decades of their life. We think about the person's family and friends, some who may not still be alive to see them actually be vindicated and released. But we also have to think about the victim and the victim's family, and the trauma that the re-traumatization, if you will, that occurs to them when, lo and behold, it seems that the perpetrator was actually not the person who was convicted. You also have to consider, in many cases where there is a DNA exoneration, we actually know, because maybe through CODIS or something like that, we know who the true perpetrator is. And like, they go on to commit other crimes. Before I was a lawyer at IPF, I was a lawyer at the New England Innocence Project based in Massachusetts. And while I was there, we had an exoneration, a DNA exoneration in a murder case, and we figured out who the actual perpetrator was. And lo and behold, they were a serial killer who went and killed multiple people after the case of the wrongful conviction. And that person was actually police's lead suspect. The serial killer was police's lead suspect until they elicited a false confession from a cognitively impaired gentleman who pointed police in a whole different direction. And so if that didn't happen, the true perpetrator, who was police's prime suspect, might have been apprehended, and the subsequent murder victims may still be alive today. And of course, to the criminal legal system as a whole, public opinion and public safety are very important. And so when these things happen, oftentimes they're big news stories. Like with this gentleman, Sidney Holmes, our last client who was exonerated in March, like, we were on CNN, we were on the big news outlets, and, that really hurts public perception of the criminal legal system and also people's notions of how safe they feel in their community. Mr. Holmes was convicted of an armed robbery in Broward County in Fort Lauderdale that he did not commit. He was sentenced to 400 years in prison. This was a crime where no one got hurt. The person's car was stolen and actually was returned later to them, although it was damaged. I don't want to make the crime seem like it was insignificant, but I think a lot of people are aghast when they realize that Mr. Holmes was sentenced to 400 years for allegedly being the getaway driver in an armed robbery where no one was hurt. But the punchline is, of course, that he did not commit the crime. He was convicted based on one eyewitness identification that was extremely flawed, and that was it. And so we ended up being able to exonerate him after a 2-year reinvestigation in collaboration with the state attorney's office in Broward County. That's me. That's my presentation. I am most certainly open to questions. I haven't had the chat open because I've had my screen, but I see there's a lot of things in the chat.
Yeah, sometimes people have points that they make during the chat that are not specific to questions to you, but if they do have a question to you, they'll have plenty of opportunity to form it in the chat if they choose, or ask you directly. So I'll kick it off, but then we're going to open it up to everybody. I've got a couple of dozen questions, but I'm not going to go through them. I'll give you just a kickstarter. Let me start with your intake process. How many do you screen, and of that screening process, how often do you do it, and how many do you accept, and what is the criteria?
Sure. So we have a very basic criteria. So one, the person has to be in post-conviction. So this is the phase in the criminal process. Like I explained before, they've already been convicted. They've already lost on their direct appeal. And so they have to be in post-conviction. We don't take pretrial cases. Oftentimes people call to us and they say, well, my public defender doesn't believe that I'm innocent. And what am I supposed to do? And unfortunately, that's the system that we have. That person is represented, and so we can't just get into the case. Also, excuse me, we're post-conviction lawyers. We're not trial attorneys. I'm not arguing anything before a jury because, quite frankly, I don't believe in it. And there's a reason why I do post-conviction work and not jury trials. We take, you have to be convicted by a state court in Florida. We don't take federal cases. And I mean, that's really our criteria. Of course, you have to be claiming your actual innocence. But other than that, that's our baseline criteria. We get about 1,000 people a year who write to us, and, it mostly starts with a letter saying, hey, I didn't do this. We have a 2-part questionnaire that we send to them to try to understand from their perspective what happened in their case and what the issues are and what their claim and their story of innocence is. For cases that, it looks like there's a plausibility that there might be something there, that the person might be innocent, we have to do a full workup of the case. And so I supervise a team of law students. Seth Miller, our executive director, who's the other lawyer in our office, we both supervise law students, and we're constantly reviewing trial transcripts, police reports, depositions, post-conviction hearings to try to understand the case and to understand, based on the facts of the case, what we know about the facts, whether the person presents a plausible claim of innocence, and then based on what our restrictive post-conviction law is here in Florida, is there a legal avenue, a potential legal avenue that can get the person back into court? If the answer is yes to both of those, that seems like it's plausible that the person is innocent and that they might have a legal avenue that we can pursue. Then we'll decide to take the case on if the person wants us to represent them. Our post-conviction law is very restrictive. And so you kind of have the substantive law that talks about, the facts and the factual basis for someone's conviction. Then we have the procedural law, and the procedural law talks about like how and when you can get back into court. In the procedural law, most folks who have been in prison for like 20 years or even less than that are essentially like procedurally barred from getting back into court unless they have something really new and really different that kind of like explodes their case open. They're going to be procedurally barred from getting back into court based on our procedural law, which is really restrictive. This speaks to the notion of finality, right? When somebody has been convicted and their conviction has been affirmed on direct appeal and they enter post-conviction, they've got their process, they got their bite at the apple, and they lost. And now we put extreme procedural restrictions on them that prohibit them in most circumstances for getting back into court. This is a very state-specific approach. Some states are very restrictive, like Florida. Before I came down here back to Florida, I was a lawyer in Massachusetts, and the Massachusetts Supreme Court has gotten rid of those procedural limitations. And so essentially their approach is that if you have a claim of actual innocence, we want to hear your evidence, we want to hear your argument. That doesn't necessarily mean that we're going to agree. You have to assess the evidence on the merits, but we're going to hear you. And the courts here in Florida and the legislature here, doesn't take that same approach. And so it is very restrictive, and we have to adjust our criteria, of course, to what the law is. And that's what the law we have in Florida is.
Just to follow up on the post-conviction, then we'll go to Fred, and then we'll go to David. Is there a way to analyze or offer up a range in time frame between post-conviction and exoneration?
It's a very long range. So anecdotally, like the client that I've had that like from the time that I first started working on the case to when they were actually released from prison, that's the shortest time period. I would say a year. And that was under some special circumstances, how that client got out. I have a client right now who has been a client of the Innocence Project of Florida since 2009. And we've been actively working on his case the entirety of that time period. And we're still very much working on his case. And the evidence of his innocence is just like so clear and obvious, and yet the court disagrees. So it can be a very long process. Of course, that doesn't guarantee success. Oftentimes we lose in our post-conviction work, and we lose on appeal. And the reality for that person might be that they're going to die in prison. So it can be a long road to an exoneration if it happens. And of course, being innocent, I tell all my interns this all the time, being innocent in Florida is not sufficient based on what the law is. You have to have particular evidence, newly discovered evidence that can get you back into court, and you have to present it at the right time. And if you don't, like the court says, too bad, so sad. So it's kind of hard to say. There's no like time frame in terms of when somebody might get exonerated, because it's not a reality for most folks.
Right. Thank you for that. Let's go to Fred, then David, then Stephen. Fred, unmute yourself. Ready?
I just well, it seems like some states, the legislators, ultra conservative legislators, I'm probably sure, like here in Florida and in Texas, they're more concerned about convictions rather than justice. And it should be, people should be outraged because if an innocent person is sentenced to death for a crime they didn't commit, people should be outraged that that's happening. And we should get rid of these, procedures and say, oh, no, you can't do it. Even if you have a whole lot of evidence that you're innocent, we don't want to hear it. But one famous case, which I actually wrote an article about a few years ago, is a man in Texas who was convicted of having murdered his wife. And it turns out the prosecutor, who later became a judge, had evidence that the person was innocent, but he convicted him anyway because he wanted an easy conviction to get his points up to say, hey, I'm a law and order guy, which is outrageous. And to my understanding, there's no law anywhere in the country where people who do that, prosecutors who do that, are held accountable. To me, if they're going to convict someone knowingly, sentence that person to death, they should be facing the death penalty for attempted murder. I don't know if it's anything you've dealt with or that, here in Florida, or because I guess that's a very high percentage of people that are convict from official misconduct,
Right.
which is pretty outrageous.
I agree. And those actors have absolute immunity under the law. And so there's very, very few instances where somebody can actually be prosecuted for their official misconduct in a particular case. I'm thinking of one case, and it might actually be the case that you're talking about in Texas, where the prosecutor was prosecuted for their direct involvement in a wrongful conviction, and I don't remember exactly what they were
I think
convicted.
it was Michael Morton. I think that's the
Okay, so
I think that's the one.
Michael Morton is the case that I was thinking of. And so I think the prosecutor in that case got like 30 days in jail or something. Don't quote me on that, but it was a very small number of days. Might even have been less than 30 days. But that's like the outlier. That might actually be the only time that I'm aware of that that's ever happened, where the prosecutor has actually been prosecuted for official misconduct. Most of the time you have absolute immunity. And that's including in a civil judgment, right? So if somebody is exonerated, they're not going to be able to, they might be able to collect from the municipality or the state, but not from the individual actor.
Okay. Thank you, Fred, for your question. David Schwambard.
Okay. Thanks, Brandon, for your presentation. It's a little depressing, but it's also very informative and important. I have two questions. First question, and you may have answered it in passing, but I just wanted to know who actually makes the decision to release somebody who has been found innocent. Is it the governor? Is it the Supreme Court? Is it the Attorney General? That's the first question. And the second question, you talked about your organization also dealing with reforms in the system. And I was wondering if through your organization it's possible for an individual citizen to find out what bill might be coming up that deals with this kind of reform, how we can find out about it. Is there something an individual citizen can do, writing letters, calling the governor, or whatever? How would we find out what we could do and when these issues come up?
Two very good questions. So the first question, who actually makes a determination where someone is exonerated? Usually that's a judge, and usually it's a judge at the trial court level. So if we're filing a post-conviction motion, we're sending that back to the trial court. If the trial court judge agrees with us, that judge vacates the conviction and sentence. Essentially, that person ends up back in a pretrial posture where the state, if they feel like they have sufficient evidence, could retry the person. Oftentimes in our situations, because we're presenting new and different evidence of actual innocence, that evidence kind of makes it not possible to re-prosecute the person at a new trial. And so the state will vacate the conviction. Although I will say that sometimes the state attorney's office is just going to retry the person again. And of course, they might win at a retrial because now the evidence is different, but the person might lose at a retrial. And that's happened before as well. There's other possibilities in other states, such as a pardon or parole. Parole doesn't really exist much in Florida unless you have a really, really old case. There's some people that are parole eligible, a few of our clients, but your case has, I don't remember the exact cutoff date off the top of my head, but I think it's like mid-90s for a first-degree murder case and like in the 80s for other cases. I mean, right, like clemency doesn't really exist with our governor, although of course it does in other states. So that could be an option for some folks in other states, but not really here. I think that's pretty much, like in Florida, the primary mechanism is either through a trial court judge, through a post-conviction motion, or of course, if we lose, we might appeal it up to the District Court of Appeal, and they might reverse and vacate the conviction, or even, the Florida Supreme Court higher up. So that's kind of the legal mechanism. In terms of the legislation, the thing that we have going right now that we're most focused on is compensation for the wrongfully convicted. And so, or I should say compensation for exonerated people, people who have been vindicated by a court. The state of Florida has really, in my opinion, the worst compensation law, because in Florida, you are ineligible for compensation by the state, no matter how long you've been, no matter how much time you serve in your wrongful conviction case. If prior to your wrongful conviction case, you either had a violent felony conviction or more than one non-violent felony conviction. So if you have 2 drug convictions, from when you were 18 and you did like a year in prison or whatever, and then at 21 you get convicted for a murder case and you do 40 years in prison for that murder that you didn't commit, you're not eligible for compensation for those 40 years from the state of Florida because you have the prior drug possession cases, in my example. So most people are ineligible under Florida's compensation law, again, for no matter how many years they spend on their wrongful conviction case, because they have some type of prior conviction on their record. So the reason why this is a bit crazy is because the data tells us that if you have a prior conviction, if you have some sort of criminal history, you are 50% more likely to be subsequently convicted for a crime that you didn't commit. So my client, Sydney Holmes, who was on the last slide, who did 34 years from armed robbery that he didn't commit, he had a prior armed robbery on his record from 1984 that he did a couple years in prison for. And then he became police's suspect in the 1988 armed robbery because he generally fit the description of the perpetrator as a young Black man, and he had this prior armed robbery on his record. And so then police have like tunnel vision. They're like, oh, well, we got the right guy because he's, a young Black man with a prior armed robbery, and he's the suspect. And so like that's essentially high level why he got wrongfully convicted, is because in part he had this prior conviction. So now he's ineligible for compensation under our state law because he has this prior armed robbery on his conviction, which like he pled to being the getaway driver in another armed robbery that happened, and he did his time and he returned back to society. So we're working in the legislature to try to get rid of that, what we call the clean hands provision in the law. And IPF has been working on that for, I think, the past 5 or so years, and we've been unsuccessful. We were almost successful this past year, and it passed in the Senate, I believe, and did not pass in the House. And so we're gonna go back to the well and try again next year and keep trying until it works.
Okay. David, you okay? That answer your questions?
I'd still like to know, if you're working on that, how can we find out that it's coming up and, then contact our state legislator or state senator or whatever? Do you have that information on your website, or do you have alerts or anything like that?
Yeah, so that's a great question. So the stuff hasn't been filed for this upcoming session yet, but yeah, we would have that on our website and like on our social media, and you can get email alerts if you go to our website and you put your email address in. We'll give you blasts every once in a while about legislative stuff, about exonerations that happen, things like that. So that's probably the best way to connect in terms of the legislative stuff, is either through social media, if you're on any of the social media platforms, which I'm not on any of the social media platforms, so I get my stuff through like just email and websites, so it'll be there too.
Thank you. Let's go to Stephen and then Diane.
I just had a quick question. Are there many cases where you're coordinating and cooperating with groups like the ACLU, or is everything you do in court on your own?
That's a great question. Yeah, sometimes we'll have co-counsel. We just co-counseled a case with the Southern Poverty Law Center, and that case was successful in March. Although the person's not released quite yet, but we co-counseled with them. Yeah, I mean, like, there are sometimes opportunities to work with the ACLU or like the NAACP on, oftentimes in our cases, we have like very extreme examples of racism. And so those don't necessarily hit on the issue of guilt or innocence, but they explain the case, maybe the prosecution, maybe the police investigation, and either through, co-counseling and litigation, or through, things that we might do in the media in terms of exposure on a case. Yeah, we might partner with outside entities who can help elevate the platform and explain some of the other issues in the case. In law school, I worked with the Georgia Innocence Project, and for example, we had one case where we co-counseled with the ACLU and Southern Center for Human Rights. So yeah, there's definitely opportunities like that. if it's advantageous to the client.
I have one more question. When we hear these issues, it sounds so horrific that anybody would serve time or be executed for a crime they did not commit. Be the advocate on the other side of the issue. What do lawyers say who are trying to defend the injustice? Is there a legal argument this old argument that it's better to let 10 people go than to execute one innocent person seems so logical. But when you go in and argue with these people, they must have an argument, which is what?
So 2 points. The argument, the rebuttal, if you will, is usually based on procedural grounds. It's usually not based in Florida. I'm talking about in Florida. It's usually based on procedural grounds. It's not usually based on the merits, although sometimes it can be when you're talking about like the credibility of a new witness or maybe some science. There might be some arguments about the credibility, but oftentimes it's like, okay, well, you should have brought like this information to the court's attention sooner. Sometimes it's not possible because the state is the entity that holds that information, and then we find it through like a public record request or something like that. But say there's a witness that could have been called at trial, but they weren't called for whatever reason. Maybe a defense strategy, or maybe just laziness. I don't know, any number of different reasons. And then you try to present that witness's testimony in post-conviction, even if they're like presenting strong evidence of innocence, like an alibi, that's like a really solid alibi or something. The state's usually going to argue a procedural barrier. They're going to say, well, that should have been raised at the time of trial. That person should have testified at trial. And so now you've like essentially waived your opportunity for that person's testimony to be heard. And so we don't care about the merits. We don't care about the facts of what that person has to say. Again, it's like, you got your bite at the apple, too bad, so sad. You should have had this person testify earlier.
Devil's advocate. I guess a prosecutor is supposed to argue one side, a lawyer for the defense is supposed to argue the other side, and then I guess even the judge or the jury is supposed to decide between the two when the facts are presented on both sides. But in terms of, I guess, bias or society's full of social agendas these days. So basically, how many people basically are actually being subject to capital punishment, which is another, I guess, argument. But what percentage in terms of shock value actually people are actually subject to being sentenced to capital punishment with regard to, I guess, any sort of crime and wrongful conviction? I can't imagine it's a majority of crimes that are wrong. And I'm not saying the wrongful convictions don't exist, but everything you're saying is, even at O.J. Simpson time, there's the idea of, police officers being so anxious to get conviction and they couldn't as they planted a glove or something. But basically, really, I think sometimes the idea of capital punishment here is being used as a shock value for all, wrongful convictions.
So the death penalty definitely plays into this. And it definitely plays into this when we're talking about race in particular.
Well, wrongful convictions are not really ever correct, but
I think,
guess, I want, if basically, if I'm going to take a position, I want, I guess, truthful, honest evidence. I don't always personally like to go off it, not just this social agenda, but any social agenda, so basically, I tend to, I guess, err on the side of objectivity or something, or think that temper blocks reason, that more or less justice is not synonymous with vengeance or whatever. basically recusing oneself if one is, got a biased interest, if you're a judge or something, or that surgeons don't operate on their own family, because basically objectivity, in terms of being able to, I guess, make reasonable judgment is sometimes necessary. So not that you don't have a point of view, or the average social judgment doesn't have a point of view or something to say, but I sort of really would like some truth rather than a social agenda these days, because people do, in order to make their point, whatever the agenda is, exaggerate. So whatever.
So
Emotion, whatever.
there's a lot of people on Florida death row. I don't know the exact number off the top of my head, but it's a substantial number. We also know that there have been 30 people who have been on Florida death row that were exonerated based on evidence of actual innocence. And that's more than any other state. It's 30 out of the 192 across the country. So this is definitely a phenomenon that exists. I think the other thing that has to be considered is how the death penalty can be used to as a weapon to coerce people into taking pleas. I have at least a couple clients that I can think of off the top of my head who were threatened with the death penalty, prosecuted in a death penalty prosecution, which often takes years pre-trial to get through, and ended up pleading out, in my opinion, to a crime that they didn't commit, because the prospect of a life sentence and fighting their case from in prison on a life sentence was, in their opinion, a better option for them than to roll the dice at trial and possibly get the death penalty and possibly be executed. I have a number of clients who fall into that boat. And so, there are definitely people who've been sentenced to death and who are innocent. There are definitely people who have been executed that were innocent. And there's also different other ways in which the death penalty can be weaponized to get people to plead to a crime that they didn't commit, or otherwise.
How many crimes actually, in terms of,
Mary, let's not make this a conversation just between you and Brandon. Other people have their hands up. I want to go around the room. You'll have plenty of time to talk afterwards, but please raise your hand. Thank you, Diane, for raising your hand and being so patient. I appreciate it. Diane, go ahead, please.
Whoops, I'm sorry. I had just forgotten to unmute myself. First, Brandon, I just want to say thank you so much. This has been an absolutely fascinating presentation. Thank you so much for taking the time to do this. A very distressing presentation, albeit. But anyway, my question, I think, is pretty quick. Now, I'm assuming that Florida has always been one of the states that has been, what is the right word? But let's say a difficult state to work with when you're, trying to work with exonerations and things. Given the kinds of people that our current governor has assigned to the judiciary and to the legislature, are you finding that it's getting even more difficult in Florida to deal with these cases, or kind of no change?
I think it kind of goes both ways. I do think that the judiciary, some say that's been stacked or whatever. It is how politics are, like go ebbs and flows, and we see this in the federal bench and we see this in the state bench as well. So there might be some bad that comes with that. I do think, though, that even in the legislature, our work has a good amount of support from Republicans. I think that there are concepts that our work invites in terms of fairness, in terms of finding the truth, getting to the bottom of things, that across party lines people can appreciate. And people can understand, well, I wouldn't want to be convicted for a crime that I didn't commit either. And so I do think that we have oftentimes bipartisan support on a lot of issues. Now, that doesn't mean that we always see the same on particular cases and particular issues, but I mean, I do think the one thing that is kind of evolving in Florida is acceptance from state attorneys' offices in terms of these conviction integrity units that I've been talking about, including, you know, in the Fourth Circuit, you know, State Attorney Nelson running on a Republican platform, but she has a conviction review unit, and they do a ton of work in terms of conviction integrity and getting to the bottom of cases. And so I don't think that this is a Democrat Republican issue. I think that this is a issue of truth. And I think there are state attorneys, whether they're Democratic or like, you know, as they say, like Soros progressive prosecutors, or like, you know, Republican prosecutors who actually care about the truth and care about getting to the bottom of the truth and are willing to, you know, right wrongs when they present themselves. So I do think that, you know, it's a little bit of good and bad. And I think it just kind of ebbs and flows with the work and with politics.
Okay, well, that does give me a ray of hope because, you know, every day I sort of lose more hope for this state, or at least for the current, you know, current governorship. But that's good to hear. Thank you so much.
Yeah.
All right. Brandon, you got anything else you want to add to that?
I did have something I wanted to add to, I think it was Stephen who said earlier, kind of the notion, and you learn this in like the first day of like criminal law 101 in like undergrad or law school, the, you know, the old principle of, yeah, it's better to let 10 guilty people go free than one innocent man suffer. It's actually a really fascinating law review article that came out, I think, like no more than 6 months ago, by Brandon Garrett, who's a professor at Duke Law School, who is one of the most prominent scholars in this area in the country. And he wrote a law review article about how society has actually changed their opinions about that principle, where if you like public opinion, if you poll people, we as a society no longer believe that it's better to let 10 guilty people go free than one innocent man suffer. And actually, a lot of people are like flipping the script and actually believe the opposite, that it would be better if 10 innocent people suffer than one guilty person go free. There's like a really fascinating law review article about kind of society's perception about that notion, how it's changed over time. And now it's like flipped.
You mentioned you mentioned earlier about some of the allies that you have that might take a case with you and join you in counsel at the trial level. And you mentioned the NAACP, the ACLU, and the Southern Poverty Law Center. Typically, your adversary is the state, I would presume, but sometimes others might join the state. Who would your foes be in terms of private, other nonprofit organizations, or foes in terms of other legal entities besides just the state?
I mean, in a court proceeding, it's always going to be the state. It's going to be the state attorney's office, or on appeal, it's going to be the attorney general's office. In terms of the media, in terms of legislation, in terms of other kind of, you know, outside of the court work that we're doing, yeah, I mean, we might get pushback from legislators. We might get pushback from other entities. I mean, I don't know of any other entity like nonprofits or whatever that like come out and hate us, but certainly like individual people don't necessarily believe in what we're doing. I think that there's a common misconception that we're just trying to get guilty people off on some like technicality, and that's absolutely not what we're doing. And even if we were trying to do that, we wouldn't be successful doing that in Florida the way that the courts are. You have to, it's like monumentally difficult to exonerate somebody based on evidence of actual innocence. You really have to like present a mountain of evidence in the state of Florida to you know, get that to happen in court. And so this whole notion that we're like trying to get people off on legal technicalities when they're guilty is just kind of far-fetched. That doesn't speak to what we're doing at all. But there are people that believe that. I suppose they would be against our work. I guess people nowadays who don't prioritize the truth and getting to the truth, because that's what we're trying to do. I suppose they would be against our work. And so.
All right. Have you witnessed an execution?
Me personally, no. No. We generally, okay, so we don't represent people when they have other counsel. We have plenty of folks that write to us that are unrepresented. And so we try to use our limited resources to represent people that don't have counsel. People who have been sentenced to death have a constitutional right to legal representation at every stage. And so they have counsel. Now, that doesn't mean that sometimes we might be asked to consult about particular aspects of a death penalty case, if it's something that we might have expertise in, like maybe DNA testing or something of that effect. We might consult with counsel on a capital case, but we don't represent people on death row directly because they have counsel. No, I have not witnessed an execution, but I did volunteer in my undergrad years. I volunteered at Florida State Prison for over a year, and I sat in Old Sparky, which is Florida's electric chair, and seen the execution room there. But no,
Is that the one they called Sparky?
Yeah, they called it Old Sparky. There's a lot of like stories to be told about that, but yeah, no, I have not seen a actual execution.
If you have a question for Brandon, please raise your hand, the emoji hand. That'd be great. Now's a good time. Have you had any experience with DNA, obtaining DNA that might be useful in exonerations through services such as 23andMe and Ancestry.com?
Yeah, so I have a couple of cases right now that we're doing genetic genealogy in, which is like genetic genealogy became very famous from the Golden State Killer, the serial killer case in California. Number of cases that have been solved using genetic genealogy, but essentially, yeah, it involves like, going through, sites like GEDmatch and building up ancestral charts and trying to say like, okay, we have this profile and this might be a third cousin of this person, and trying to work back through it that way to figure out who to develop a suspect essentially, and then investigating that person. So yeah, we do. It's very expensive to do. It takes a lot of time, a lot of people resources as well, but we do have a lot of cases that, or not a lot, we do have a couple of cases that fall into that category.
Mm-hmm. Mm-hmm.
I see on in the chat a question from Marilyn. Question: how do you give all the social services with one social worker? It's a really great question. And the question is, or the answer is that we're hiring a second social worker. So yeah, it's really hard, the number of clients that we have for one person to do all of that type of social work that's necessary, both for our incarcerated clients and our freed and exonerated clients. And so we've recently decided that we need a second social worker. So we're hiring a second social worker.
Okay. Fred?
I'm just curious if there have many cases, or is it like a really small percentage that where it becomes known that someone else has come forward as the actual, culprit, like murderer or whatever. Yeah, I did it, but that guy got convicted, but I'm the one who did it. But I know there are at least a few cases like that I've heard of where, and of course they're saying, no, we're going to give, we already convict this person, we're going to keep that. But is that something that really happens that often, or just very, very rare?
It's pretty rare that the actual perpetrator gets identified. It usually only happens in DNA exonerations where you get a hit in like CODIS or something. We had a case recently, an exoneration in Tampa that happened in 2019, 2020. And we determined based on a CODIS hit who the actual perpetrators were. And the state attorney's office there is prosecuting those people. Currently, I believe they were in prison for another crime or maybe multiple crimes. I don't recall off the top of my head, but of course that decision we don't have anything to do with. To the extent that the true perpetrator is identified, of course, the state attorney's office has to determine whether they can prosecute them. There might be certain circumstances where they don't prosecute them. Obviously, if they don't feel like they have sufficient evidence to get a guilty verdict beyond a reasonable doubt, or they might be incarcerated for other crimes, and they might feel like a prosecution is kind of moot. Maybe they might be serving a life sentence for some other act. But of course, like if it's a murder case, then you could seek the death penalty against them. It's kind of like whatever the state attorney's office decides to do at that point. But I think it's pretty rare generally for the true perpetrator to be identified, although it does happen.
What kind of post-exoneration services do you offer as the Innocence Project of Florida, if any, or do you refer them to other agencies?
Yeah, that's a great question. So we have a full-time social worker, but of course, every client has particular needs. And so they might have dental needs, they might have medical needs, they might have PTSD and trauma related needs that our social worker can help with therapy and things like that. But sometimes he's based in Tallahassee, we might have a client that's in Fort Lauderdale, or they might move out of Florida and they might be living in Georgia or some other state. And it just makes more sense to connect them with somebody who's local to them in terms of therapy or mental health counseling, whatever they might need. Obviously, if they need things like medical and dental needs, we're going to try to help them, and we're going to try to either get pro bono help for them, or we'll pay for it to the extent we can, things like that. We have a part of our total operating budget goes to social services for helping folks with various needs that they have. Of course, like we can't buy a house for somebody, but we might be able to help them with rent. We might not be able to buy a car for somebody, but we might have a generous donor who is willing to like give up their car that they were otherwise just going to trade in, something like that. So yeah, we try to be creative in ways that we can help our clients after exoneration to the extent that we can, both in terms of people power and financially.
Um, you mentioned your budget. What is your operating budget? Can you share that?
So I'm not a finance person, but as far as I know, our operating budget is something shy of $1 million.
Oh, wow. Oh, that's interesting. So you mentioned this earlier, I'm pretty certain, but it's, if you wouldn't mind repeating it, how many active cases do you have, are you working on currently?
How many active clients do we have? That's a great question. I think that we have about 30 cases that we are actively working on that we have agreed to represent. That does not count, like I'm constantly, and Seth, our executive director, who's our other lawyer, we're constantly working with students to work up potential cases, which we accept a percentage of those types of cases. But in terms of cases that we've actually agreed to represent the person on, I would say about 30.
Wow. Okay. What is the demeanor of the people that wind up being exonerated? Do they go vacillate between great joy and finally being heard and released and understood and found innocent, and bitterness? Is there bitterness to them, or what do you notice in their demeanor?
I think so from my experience, both for my clients who've been released, but also other exonerees that I know, I think the general feeling is happiness and appreciation, and just kind of wanting to put the past in the past and move on to the next chapter in their life and try to assimilate back into society the best they can. I definitely have clients who were bitter to their core and angry about what happened to them. And I do think that sometimes that can affect one's ability to properly or healthily assimilate back into society. What their mind space is, of course, 40 years in prison, 30 years in prison can do a toll on somebody. But I think the vast majority of my clients, in my experience, have, and my clients who are in prison who have not been exonerated, are very hopeful and just kind of want to move on with the next chapter and don't have resentment and don't have bitterness overall. There might be some days where someone wakes up and they're in a bad mood kind of thing, but overall, I think it's kind of like we just want to put the past in the past.
Mm-hmm. Are you familiar with a play called The Exonerated? It premiered in Off-Broadway, New York in the year 2000, and it traces the lives of 6 people who are on death row through their legal proceedings in a Reader's Theater type setting. It won lots of awards. It played over 600 performances. I wonder if you've used that maybe as a fundraiser, because that would attract a large crowd, and it's an easy production number, and it's extraordinarily poignant. Are you aware of it?
I am aware of it. One of the 6 is an exoneree off death row from Florida.
Mhm.
But I saw it in New York when I lived in New York. It's very great. It's I think they made it into a movie too, right?
I'm not sure if they did. They may have. Yeah.
It's a movie, but it's a great play.
Mhm.
Uh, have we thought about uh, using that for a fundraiser? I have not, but I can talk to our fundraising person because I like that idea. I think it's great. I think it's a
There you
great
go.
idea.
There you go. There's a couple of hams in this audience who might be able to help you out. I don't. Um,
I have no creative talent. I wish I did. I very much respect and appreciate people who have creative talent. Um, so I would not be one of the performers. No one would come to see that, but um, I like the idea quite a lot.
Mhm. Oh, if you do it, I'll drop by and say hello and see it. Let's say if you have a question, now's a good time. We're getting ready to wind this up. Brandon's been with us for an hour and a half or so. I see Stephen, you've got your hand up. Please raise your hand if you do have a question. Stephen?
Yeah, I was just going to say that the exonerees that I've seen in interviews are amazingly kind and not angry and not resentful. And the guy that was just elected to the city council in New York, one of the
Yusuf Salam.
rape, yeah, amazing guy. And I'm more resentful than he is, and he was treated horribly. So I guess when you're released after being locked up, the joy of that overcomes everything else, but seem to be amazing people, the ones that are public with their exoneration.
Yeah, I've I've done a number of interviews and stuff with Sydney, our last exoneree, and I was representing him for 2 years, and so I feel like I know him pretty well. We just did a podcast episode together on the Wrongful Conviction podcast, and he tells his story, and he's asked point blank, like, are you mad at the system? Are you mad at the state? And he's like, no, I can't have hate in my heart. I'm just glad that the state attorney's office finally, saw that I was innocent. He went to prison. His daughter was less than 1 year old. And so now she's pretty much the same number of years as he spent in prison, wrongfully convicted. And so I think from his perspective is just like, I want to get to having a better relationship with my daughter.
It's hard, I think, for average people to relate, but you get the same feeling from Holocaust victims who don't have this bitterness that I would surely have, and I do have. And it's amazing how people can go through such horrible injustice and come out on the other end positive,
Yeah, that's truly amazing. I mean, I think I don't want to be so bold as to like put myself in a situation that I've never been in, but I could imagine possibly it's like, a life sentence or a 400-year sentence in the state of Florida is really a life sentence. So if you get sentenced to life, that's a life sentence. And I imagine, being at a concentration camp, you might also feel that death sentence. And so to get out from under that, to survive that, obviously there's immense trauma and pain and suffering, but I can only imagine that to survive that, you must be just like happy and grateful and want to put that in the past to the extent possible.
Also guilt,
Right.
a lot of guilt, survivor's guilt.
I see that too because like word travels in prison, and so I have clients who are friends with other clients, and of course I don't tell people who else I represent, but they somehow find out that like our office represents each other, and then like say one of them gets exonerated and the other one is still in prison fighting for their freedom. Yes, survivor's guilt definitely can set in for that. They feel the person who's released, who's exonerated, is obviously very happy for themselves, but they have met other people along the way in their incarceration that they believe in, and those people haven't been vindicated yet. And so the question of like, why me and not them is definitely very real.
Very good. Thank you, everybody. Last call for a question. If hearing none, if you do have one, now's the time. But hearing none at this moment or seeing no hands raised, I appreciate raising the hand. That keeps things kind of orderly. I'd like to ask Brandon if you'd like to summarize things that you would like to be sure we take away this evening, because you gave us a lot of great information. How would you sum it all up for us? What can we do to help you? What can we do to help you?
So I think the questions about, you know, what can we do in terms of calling our legislators, I think is very important. I think sometimes, like, you know, you need to go and vote can be a little bit cliche, but here I actually think it's very important at the local level, because people don't really know, generally, I think people really don't know and appreciate how much power their elected state attorney has, both to prosecute, but also to right wrongs. And so, you know, I mentioned a couple of times these conviction review units. You know, there's one in the Fourth Circuit with State Attorney, you know, Melissa Nelson, who really cares about this issue of wrongful conviction and has a really great conviction review unit that does a whole lot of work and really take it seriously. And I would like to see more state attorneys throughout the state of Florida, you know, creating these units, not units that are in name only, but units that actually, you know, truthfully look into the matter of whether somebody has been convicted for a crime that they didn't do, and work with an organization like ours to get to the bottom of it. And so I do think that voting at the local level for, you know, a state attorney election, where you have somebody who's really prioritizing, you know, the truth and getting it right, not only, you know, looking forward, but also looking back, I think that's really valuable. And so, you know, voting, and sometimes these state attorney elections are very, very close, because obviously there's fewer people voting as opposed to a whole like statewide election. So I do think that that really matters.
Okay.
Yeah. You know, we are a nonprofit, so to the extent that anyone is compelled, we do operate primarily on individual donations. But other than that, I think there's a lot that can be done from a grassroots perspective, both with your, you know, local state attorney and your local legislators.
Okay. Very good. I thank you very much for your time, your expertise, your wisdom, your generosity with us, and your willingness to listen to all of our questions and answer them fully and completely. I enjoyed your presentation immensely. Now's a good time to give Brandon a hand clap and a thumbs up, or whatever we want to do for Brandon, and wish him all the best. And I wish everybody else here all the best. And we'll see you in September. That's our next public meeting that we have, will be in September, when we get to hear our good friend and buddy Eric Freiberger, who will talk to us about liberals and conservatives and what they have to say about liberty and more stuff. He's a philosophy professor over at the Jacksonville University. Brandon, once again, our heartfelt thanks and the best of luck in all of your work.
Thank you, thank you, thank you, thank you. Awesome presentation.
Thank you. If anyone has any follow-up questions, I know this is like very thought-provoking. Feel free to reach out. The folks here have my contact info, and so I'm happy to answer any questions that you might have.
I have one last super quick question, if you could post it on the website. But do you guys use volunteers
So sometimes we do.
to help with research and stuff like that?
Yeah, sometimes we do. It depends on kind of what the person is looking to do. We have like a volunteer coordinator who kind of takes in inquiries, and if there's a fit where that person is, wanting to do something and we have a need for that, then yeah, we do take volunteers sometimes for sure.
Okay, well, Jeanette, there you go. Be on the lookout for Jeanette. She might be volunteering.
Sounds good.
All right. Thanks so much, Brandon. Thank you, everybody. Everybody, drive safely. Get home in one piece. Thanks so
Night.
much. See you next time, September. Good night, all.
Thanks.
night.
Good night.